2025 brings more changes to UK immigration. There are big updates to visa rules, moving workers, and compliance needs. Let's check out the latest changes and how to adjust. From sponsorship fees to electronic travel authorization rules, here's what you need to know to keep your business running smoothly and growing. In recent years, UKVI has made it clear that enforcing sponsor compliance is a top priority. In 2024, the government became stricter, focusing more on ensuring sponsors follow the rules. By the third quarter of 2024, 513 skilled worker sponsor licenses had been revoked, which is higher than the 377 revocations in all of 2023. Sponsorship is now seen as a privilege, not a right, and this increased scrutiny will continue into 2025. UKVI has already started to enforce new rules, including a restriction that prevents skilled worker sponsors from passing on the cost of the sponsor license application or any related administrative fees to the worker. The UK government has made a major change to sponsorship costs for skilled workers. Starting December 31st, 2024, sponsors cannot pass certain sponsorship costs onto the worker. This change is meant to reduce work-related debt and exploitation. The following costs are now prohibited from being passed on to sponsored workers. Sponsor license fee. This includes fees for new sponsor license applications or adding the skilled worker route to an existing license, starting December 31st, 2024. Certificate of sponsorship fee. Employers can no longer pass on the fee for a certificate of sponsorship issued on or after December 31st, 2024. These rules are similar to the existing rule that prevents employers from passing the immigration skills charge onto workers. However, employers can still recover other costs, like visa application fees, service charges from the Home Office's commercial partners, and immigration health surcharges. Failing to comply with these new rules can result in the loss of your sponsor license. This can cause reputational damage, financial losses, and serious disruptions for workers who are already sponsored. Employers should take the following steps to stay compliant. Check and update your internal policies about sponsorship costs. Make sure your employment contracts, side letters, and clawback agreements are in line with these changes. Consider how these changes will affect your company's immigration budget and future recruitment. UKVI policies will continue to change, so it's important to stay updated on any new changes. The ETA allows travelers to enter the United Kingdom, similar to the US electronic system for travel authorization. It applies to visitors who do not need a visa for tourism, transit, family visits, business, or short-term study. It also covers those coming for up to 3 months on the creative worker visa concession or for a permitted paid engagement. However, it does not apply to people with a UK visa, those authorized to live, work, or study in the UK, or British or Irish nationals. The ETA will be mandatory for non-European nationals, including US nationals, starting January 8, 2025. Non-European nationals. From November 27, 2024, eligible non-European nationals can apply for the ETA, which will be required for travel or transit through the UK, starting January 8, 2025. European nationals can apply from March 5, 2025, and the ETA will be required from April 2, 2025. By April 2025, all travelers to the UK, except British and Irish citizens, will need either an ETA or an e-visa. The ETA is not a visa and doesn't grant the right to live or work in the UK. Visitors must still comply with the UK visitor visa rules. If someone needs to work in the UK, they must get the appropriate visa before traveling. Employers should review their travel plans for the next 6 to 8 months to ensure overseas employees have the necessary ETAs. Failing to obtain an ETA may cause delays or refusal of entry to the UK. Employers may also want to update employees on the rollout of the scheme. Employees should check their passport validity and apply for their ETA in time. Any concerns about the application should be raised early. UK visas and immigration is moving towards a fully digital immigration system. In 2024, they began replacing physical documents like the biometric residence permit with digital e-visas. UK Visas and Immigration has confirmed that expired documents will still be valid for international travel until March 31st, 2025, to address technical issues some people faced when getting e-visas. This extended timeline may be reviewed as needed. If your employees hold a biometric residence permit, they can still use it as proof of their permission to travel to the UK until March 31st, 2025. However, they should create an e-visa account on the gov.uk website, if they haven't done so already. Creating an e-visa account will allow employees to access and update their immigration status online, as well as provide proof of their right to work and rent in the UK. The graduate visa remains a key option for businesses looking to hire international graduates from UK universities. As of November 22nd last year, the Tier 4 student graduate switch to a Skilled Worker Certificate of Sponsorship, COS, is no longer available on the sponsor management system. The process for assigning COS to individuals switching from the student or graduate route to the skilled worker route has been updated. This change is now reflected in each company's sponsor license system. Employers wishing to sponsor a student who has completed their course and wants to apply for the skilled worker route must now use the new COS category, Skilled Work. Student course, complete switching to skilled worker. Students switching directly to the skilled worker route will still be exempt from the immigration skills charge. This change helps reduce mistakes, as many sponsors previously selected the wrong category when sponsoring graduates, leading to application refusals or delays. Sectors like technology, finance, and healthcare have used the graduate visa to fill skill gaps. For example, a fintech startup in London recently hired 3 graduates under this route, which helped reduce costs. As the UK government continues to review post-study work policies, businesses should stay alert to any changes that could either improve or limit access to international graduates. It's crucial to ensure that right-to-work checks are done properly when hiring individuals, especially for employers with a sponsor license hiring staff from abroad. As of September 23rd last year, the right-to-work checks also apply to employers who hire staff under a service or apprenticeship agreement, as well as those on an employment contract, whether written, verbal, or implied. This means that even if the worker is not a direct employee, the right-to-work check must still be done and evidence must be kept that it was completed. Once this is done, the business meets its sponsor duties. The employer is responsible for the civil penalty if the right-to-work checks are not done correctly. This responsibility lies with the employer, not the staff doing the checks. Even if an external identity service provider is used, it's still the employer's duty to ensure compliance. The employer will be liable for the civil penalty in 2 situations. If it's discovered later that an employee is working without the necessary right to work. If it's reasonably apparent that the check wasn't done correctly. A check done by a third party is not considered a valid excuse unless it's for British or Irish nationals with a valid passport. As we approach 2025, the UK's new immigration rules could impact millions of people, forcing them to reconsider their future in the country. It's important to stay informed and be proactive in understanding how these changes might affect you. If you found this video helpful, make sure to like, subscribe, and hit the notification bell so you don't miss any important updates on UK immigration and more. Let us know in the comments how you think these new rules might impact the UK and your plans. Thanks for watching, and we'll see you in the next video.